Think the Constitution protects equal rights for women? Think again. This is the untold story of the Equal Rights Amendment. Did you know that it took women in America more than 130 years to gain the right to vote? And even then, many still lacked the same basic legal protections enjoyed by men. It's why in 1923, feminists Alice Paul and Crystal Eastman drafted the Equal Rights Amendment, a proposed change to the U.S. Constitution that would finally guarantee equal legal rights between the sexes. But not everyone thought that was a good idea. And back in the 1920s, opposition to the amendment didn't just come from men. It came from women, too. Some working-class women worried that if the amendment passed, they would be forced to work longer hours and be expected to do the same types of work as men. It took 49 years for the amendment to finally pass through both houses of Congress. The ERA needed to be ratified by 38 states by a set deadline to become part of the Constitution. And ratification seemed like a sure thing, until people like Phyllis Schlafly got involved. Schlafly argued that the ERA would cause women to be drafted into the military and even lose custody of their children in divorce cases. She mobilized conservative housewives to write letters to local politicians. Some even lobbied legislators with homemade jam and pies. The deadline for the ratification came and went, but supporters of the ERA didn't give up and chained themselves to the entrance of the Illinois Senate to get the deadline either removed or extended. An activist even wrote the name of an opposing legislator in pig's blood on the floor of the Capitol building. Fast forward to 2020, and Virginia finally became the 38th state to ratify the ERA. But with the deadline passed, the fight to make the ERA a constitutional amendment goes on. What are the reasons for and against making the ERA a constitutional amendment?